And then the most recent cases to get to the court involving public displays. Two cases. First one, 2009, case out of Pleasant Grove, Utah. Kind of an interesting fact situation. I mean, the Pleasant Grove had also a Ten Commandments monument already in place, which probably is okay based on the Austin decision, right? Because they have a number of other monuments. Right? And so another group of people, a religious group, a small religious sect in Utah called the Sumums, said, you know, if the Christians get to put up their Ten Commandment monument, shouldn't we be able to put up our 7 aphorisms monument? They had 7 aphorisms. It's kind of an interesting backstory there. The Sumim believe that when Moses went to the top of Mount Sinai, he actually got 17 commandments from God, not 10, as most people would think reading the Bible. But 7 of them were just too heavy for people at the time. You know, you can't lay them on people right now. They wouldn't be able to handle these 7, and so only a select group of people received these extra 7 aphorisms or principles. And now the Sumim have hold of these principles, and they want to share them with the world on their monument, right? So if they put up the 10 Commandments, they should put up ours. In case you're curious, the 7 principles of Sumim on their website here. The universe is a mental creation, just one. Nothing rests, everything moves, everything vibrates is principle 3. Gender is everything. Gender has its masculine and feminine principles. Gender manifests on all levels is principle 7. So you know, those are, that give you a sense of what their monument would have on it. So their argument is, well, why not ours? And Pleasant Grove didn't want to have any part of the Sumim monument in the public park. Sumim sued, goes all the way to the U.S. Supreme Court, and the Supreme Court decides it's actually on free speech grounds. The Sumim were trying to argue that what Pleasant Grove had done is create sort of a public forum. They're allowing people to put monuments up, so they have to allow ours up as well. Supreme Court majority here, anyway, 5 members of the court said, no, that's not what happened. What happened was Pleasant Grove accepted certain monuments on the property, and when they accepted those monuments, they became the speech of Pleasant Grove, Utah. Right? So the 10 Commandments are Pleasant Grove speaking, as are these other various monuments. And the government can say whatever it wants. So essentially, that's what the court says. It's kind of a remarkable free speech decision in a lot of ways. If you read that decision, there's nothing in the decision that suggests anything unconstitutional if all the branches of the government were controlled by the same party, so the Republican Party. The Republican Party is plastering across every interstate highway big signs that say vote Republican, right? Because that's government speech then. And this case seems to say if the government's speaking, they can say what they want. They're not limited. The First Amendment only applies when the government tries to limit somebody else's speech, but the government can say what it wants. For dissenters suggesting there might be a problem with that. It seems like there might be. Maybe there'd be an equal protection argument or something else that we brought in those cases. And at the same time, in their decision, the Supreme Court said, and by the way, don't worry about that monument there, the Ten Commandments monument being a problem. We already said that's okay. See the Texas. So that's where we stood in 2009. The most recent decision of the Supreme Court, 2010, in the case of Salazar versus Bueno, involved a 8-foot-high cross, white metal cross, that had been put up in 1934 on a national preserve, federal land in California, Mojave Preserve, put there in 1934 by the VFW to honor World War I war. The question is, what to do about it. The district court that first addressed this issue said that looks like an establishment clause violation. This isn't just 10 commandments that have some sort of history in our rules and rulemaking and approach to the world. This is a cross. It's a symbol of Christianity. It's got to go. The federal government then said, well, we don't want this cross to go, essentially. How about we make a little trade? We'll take a little piece of land that this cross is on, cut a little chunk out here, essentially, and we'll trade that land for some land on the outside of the park, outside of the preserve, that's now in private hands, and we'll just make a trade, right? So the cross suddenly becomes on private land, even though it's surrounded by public land. And won't that take care of things? That was the argument. So it goes back to the district court. The district court says, no, you can't do that. That's just an end run around our earlier decision. The land trade is invalid. It enjoined the federal government from making that particular trade. It goes up to the Supreme Court. The Supreme Court looks at it, and essentially what it says in a 5-4 decision by Justice Kennedy, I don't think that crosses the problem. So you probably wouldn't have had to do this land trade, but in any event, I'm going to lift the injunction and send it back to the lower court to consider. But the way I look at it, it's not a problem under the statute. Tell you what, and he says in his opinion, if you look at that little white cross up there, it can't go as high as a little, but you look at that cross, what does it remind you of? He says, well, what it reminds me of is all those little white crosses around all the fields of Europe that are in the cemeteries of our war dead. And therefore, it serves this secular purpose of reminding us of all of those who lost their lives in the war. It's not primarily reinforcing a religious message. Therefore, it's okay. That was his view. And so 5-4 essentially says that cross stay. I think that's so where do we stand? Well, where we stand is where Justice Kennedy stands. He today is the swing vote in all of these cases. And the key thing to note about Justice Kennedy with respect to all of those displays that I've just gone through is that Justice Kennedy did not view any single one of those displays as a violation of the Constitution. Justice O'Connor, Justice Breyer were swing votes in some of those cases, but Justice Kennedy was always on the side of finding the religious symbol to serve some sort of non-religious purpose, being non-proselytizing. So, does that mean anything goes with respect to religious displays? Well, not anything. What exactly would Justice Kennedy, where would he draw the line? Well, he says where he drew the line, actually, in the Allegheny County case when he wrote his concurring opinion. He says, the Establishment Clause forbids the city to permit the permanent erection of a large Latin cross on the roof of City Hall, because such an obtrusive, year-round display would place the government's weight behind an obvious effort to proselytize on behalf of a particular religion. So that's where Justice Kennedy's coming down. If the symbol can be viewed as an attempt to proselytize, he's off the boat, right? If it can be viewed as serving any other kind of purpose, reminding you of the seasons, reminding you of war dead, whatever it is, he's all right with it. But if it's just a pure attempt to proselytize, he's going to draw the line back. And that's where the center of the court is.